Order of the Cascade Charter Township Planning Commission for Monday, December 18th, our last meeting of the year, at exactly 7 o'clock. Please record the attendance. I believe everybody is here. We have 7 members on our side.
Except member Nordike is.
That's right. And I'm filling
He's
in
absent.
for Chris. Chris is out of the country, I believe. Please rise and for the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have a motion to approve the current agenda.
So moved.
Support. Moved and supported. All in favor, say aye.
Aye.
Any opposed? None noted. Is there any conflict of interest by members of the Planning Commission?
I don't believe so.
Okay. Like to review and approve the minutes of the December 4th meeting. By the way, it did say March 20th on the top of the minutes. We could change that. I'd appreciate it. Any comments?
I had 2. The case, Article 7, case 233798. The last paragraph in that first requested action section. It says member Bruno questioned the amount of wood inventory in the applicant's existing home property. Sam says hobby is milling lumber and he needed storage for the items that were previously kept. I think the and after that's not quite right. Sam said his hobby is milling lumber, not a consumer of the end product. He's not storing it. He has no intention of storing what he makes in his place. He makes it, he palletizes it and leaves it outside and hopes that someday he'll have a use for it, but he doesn't currently have uses for it. He doesn't operate a business.
And he doesn't sell it.
And he doesn't sell it. So the and is incorrect there, if we could fix that.
Okay. Any other comments on the minutes?
I had one. I'm trying to find it.
I have one in Article 9,
Joe?
would be the 4th paragraph, Article 9, last sentence. If the commission choose to approve due to the unique circumstances of the applicant, comma, she listed conditions in the packet. I think that's just an editing issue. I think it probably meant to read, she recommended it be subject to the conditions listed in the packet. That's how I recall the conversation. Does that make sense to folks? Well, it would be I guess it would be the 3rd paragraph after the requested action. Addison, if you look down, it's the one starting with staff recommended. And at the very end, just a little edit there.
Any other changes?
My second one.
Oh, I'm sorry.
Yes.
I didn't see you through him. You want to fit? You got more?
No, I'm good. Thank you.
Member Bruno?
Article 8, Josh Baker. I'm not really sure. It's not like a specific spot in here, but there's an entire conversation. The packet reflects that they need more parking spaces than the 23. And Josh or his architect that day came with different math than was in the packet. And therefore we came to the conclusion that the 23 spaces they had drawn were sufficient. I think that should be mentioned in there somewhere, because if someone were to look at the packet, this doesn't match.
I would agree.
Any other comments by members? Can I have a motion to approve the minutes of the December 4th meeting?
So moved.
Support.
Support by
Member Rissy.
Member Rissy. Okay, thank you. All in favor, say aye.
Aye.
Any opposed? Motion passes. I'd like to now acknowledge any visitors we may have either in person or online that wish to speak. Comments are limited to 5 minutes per speaker. Do we have anybody online? And folks, we have Mr. Schrotenboer and Mrs. Schrotenboer. We have you on the agenda. Okay, so let's move on. Article number 7, case 233801, Epic Homes, the Schrotenboers. Property address 3660 Cherry Lane. Requested action seeking a type 1 special use permit for an accessory building exceeding 832 square feet.
Yes, so we have the Schrotenboer household back here tonight. They were tabled at our previous meeting, pending some modifications or revisions to their plans that might make it more in line with what the planning commission would like to approve. So to present their amendments, they are now requesting, they've reduced the size of the building to be 40 by 64 pole barn, that's 2,560 square feet. And then they've reduced that lean-to just be an 8 by 8 cover over the door for accessing the barn for a total of 2,624 square feet. So they were meeting our need to be more in line with the what they would be permitted in 3 accessory buildings, which was the 2,496. Additionally, the design is presented to be painted in line with the home that's being built right now. Though that addresses the specifics that were asked to be revised. I can go through the whole application again if you guys would like me to, or are you okay with me speaking to the revisions from the previous meeting? Go ahead.
And I have to be careful how I ask this question because is the building footprint, not the overhang with the posts, but from what they originally proposed, is the actual enclosed building area square footage similar to what it was before? So they just eliminated the overhang?
Correct.
Okay, that's okay. Thank you.
So with these revisions that they made, I was able to then also determine with conversation with the applicant that the neighbor to the north who would have been impacted is no longer concerned about a negative impact because of the standards set in their variance approval. So I am able to recommend approval of the accessory building today with our typical conditions that the building not be used to run a business or for a dwelling space, and that their outdoor lighting would adhere to our township standards to which the applicant has agreed to.
I have one question for you, Madison.
Yes.
We at our last meeting, we asked for a water diversion control plan be created and reviewed by the township engineer, Eric Thorne, prior to building permits being issued. Included in this plan must be a survey. Has that been done?
So that was a condition of the zoning variance. So because they haven't submitted their building permit to build, we haven't required them. I mean, they are required as a condition for them to build. So usually them applying for that permit would trigger us saying, okay, we need X, Y, and Z before we can issue this permit. So we just haven't reached that stage quite yet, but they are aware
Okay.
of those
It will
conditions.
be done.
And it will, yeah, yep, we will uphold those conditions.
Okay, I just want to make sure that the water that is diverted goes off towards the wetlands on the east side.
Definitely. Yep, that was one of the main concerns.
Okay. And so we're going to be 21 feet from the north property line if we give. Okay. All right. Any other comments?
I have no more comments.
Would the Schrotenboers like to come up and make any comments? Good evening.
Good evening.
I don't
have any comments?
Yeah, no, we really don't have a whole lot. I feel like we've met the criteria that we talked about the last couple of meetings, and so hoping that we can move forward.
Okay, and the neighbor to the north, is
Yeah.
fine with what's going on?
Yep, yeah, they were fine, ever since we agreed to do the evergreens that we talked about last time. And, right, and the water diversion, obviously. So yes, they're good.
Now, the building runs long direction, north-south?
It'll run east-west, so,
East-west.
yeah, the long part, yep,
Okay, so kind
exactly.
of parallel to the property line?
That's correct, yeah, the garage doors will face Cherry Lane, will face to the west,
And then you'll have the 5 trees
right, yep.
along.
So we have
with
to figure out placement of the trees yet to make sure that we are in line with where, yeah, exactly. So where they will, obstruct their view, I guess, if you will. So,
Okay.
Mhm.
Well, if you use evergreens, you can put Christmas lights on them to stand there, right?
perfect.
Yeah, okay.
We'll plant one every year and then in 10 years, we can start cutting our own Christmas trees.
Okay, do any of the members have any questions for the Schrotenboers? Scott?
The lean-to, if you will, the overhang area.
Yeah.
That's dramatically smaller from what was proposed before.
Mhm.
Do you feel it adequately meets your needs? I mean, do you feel that this is a huge love loss over this, or are you comfortable with this proposal?
I mean, it's a love loss personally for me, right? I was really looking forward to having that extra storage space there, but again, we want to make sure that we're, in agreement with everyone.
Okay.
This will give me protection getting in and out of the building, which will be great. So yes, I mean, if you're offering to give me the lean-to back, I would take it, but I won't sit here and I obviously am not gonna argue about it. So I feel like it's in a great spot now.
Any other questions?
I just want to say thanks for, sharpening your pencil. By my math, you're within 5% of, 3 times the 1 to 832. So that's
Great.
negligible. So we appreciate that.
Thank you.
Yeah. Thank you.
Sure.
Okay, thank you. Can I have a motion?
Yeah, I think I'm working on it.
Wait a minute. Don't you want to go to public?
Any further
There isn't
discussion?
one. No. Okay.
We already did that. You weren't here that day.
Okay. Yeah, no.
I'm gonna throw something out and maybe it'll gain traction, maybe it won't. But I'm gonna float an idea here. I just need 1 second to create this. So in case number 233801, I would move to approve the building. What was the size in her report? I can't find it. I'm sorry.
26 with everything, I think.
2624? Okay. I would move to approve them up to 2,800 square feet, which is a little bigger, doesn't give them the full length of the building overhang, but gives them a little bit more overhang. Some quick math, run 20 more feet. So I'm just gonna float this. Maybe you guys will strike it down. I'm gonna throw it out there.
Why?
Why?
I mean, I'm not being a jerk. I'm just asking why.
Everybody has a different opinion as far as how big accessory buildings should be allowed. I'm comfortable with that. That's just it's smaller than what they requested, so I think it comes more in line with what some people's thought process was. I think the building would look better with a little more overhang on it. I think it gives him a little bit more of an outside area on a rainy day. I think there's, to do some things. I'm just throwing out an idea. That's all. So I would approve it at 2,800, move to approve it at 2,800 square feet with the usual conditions. It can't be used to run a business, a residence, or any outdoor lighting would need to meet our needs and our township rules. And also I would add a reference that it has to match the ZBA's opinion as well, just so that The two are tied together.
So that's the problem I have. I think the ZBA already made a statutorial error in permitting it, to be honest. If you go through the statute, we can't revisit that.
Right.
But so we're gonna give them that, and I think we're giving them the multiplicative of 3 plus an additional 5%. At this point, we're going back to what almost to where Maddie was, which is staff denying.
Well, then you guys cannot support, my
Just have
motion
one-
and vote it down,
Well,
or
that's me, like-
I'm just throwing it out there. I'm just floating an idea. We don't have a large crowd in here tonight, so I thought I could take a minute to do that, but.
I'll support your motion.
We have a motion and it's been supported. I'd like to take a vote now. All in favor, say aye.
Aye.
Aye. Any opposed?
Opposed.
2 opposed, 5 support. Motion passes.
Thank you.
Thanks, folks.
Thanks for coming back in.
Thank you.
It's gonna be a beautiful house, by the way.
Thank you.
Very nice.
You're welcome to stop by anytime.
Got a great view
Uh-oh,
there.
you will. Bring a train over. Look at the big barn. You better put a pretty nice train set in that barn.
Huge train set.
Thanks for coming.
Thank you.
Take care.
Okay, I'd like to now move on to Article 8, ordinance amendment. Requested action to schedule a public hearing to amend section 23 of the zoning ordinance. We have our attorney here today to talk to us about that. Mike Palmier?
Yeah, good evening, and thanks. The township manager asked that I be here just in case there were any questions. What we've done is propose to remove the establishment of the planning commission from the zoning ordinance, only because it really doesn't belong there. Neither do the bylaws for that purpose. For a couple different reasons. One is it's not specifically authorized by the Zoning Enabling Act. It's authorized the creation of the Planning Commission. The continuation is authorized by the Planning Enabling Act. And so back in 2008, well, go back to 2006, the legislature consolidated all of the zoning and plan or zoning acts at that time, the City Village Zoning Act, Township, Rural Township Zoning Act, and the County Zoning Act into one. 2008, they did the same, but with respect to the planning acts. So County Planning Act, the Township Planning Act, Municipal Planning Act were all consolidated now into the Planning Enabling Act. That statute authorizes the township to create or continue the planning commission by ordinance, but not necessarily the zoning ordinance. So there aren't many municipalities that will include it in the zoning ordinance. There are a couple, albeit I don't think correctly, as a legislative action creating the planning commission under the Zoning Enabling Act. So what we've done is we've deleted those portions. It's going to require then eventually the planning commission to adopt new bylaws. I know the planning commission had worked on that. So you'll have that opportunity to then adopt those bylaws. If you were to adopt or change your bylaws and they're included in the Zoning Enabling Act, the township board ultimately would have the authority to pass on those bylaws. Where if you look at the Planning Enabling Act, the Planning Enabling Act actually allows the Planning Commission to adopt its own bylaws without regard to whether the township board agrees with those or not. Now, they can't be inconsistent with the legislative authority creating the Planning Commission. But for example, unless the township defines what a conflict of interest is, the Planning Commission gets to decide and then put that in its bylaws on how you define a conflict for purposes of recusal. So we're just trying to clean up the ordinance. I know we've had discussions with the township for a long time about this, and this is kind of the first step in setting that public hearing.
One question I have is, would you do the same thing with the zoning board of appeals?
No, because the Zoning Board of Appeals is actually authorized under the Zoning Enabling Act, which is why in the proposed draft, we left those provisions intact underneath your zoning ordinance because that's where it arises.
But in the final revised draft, you change all the ZBA notes to planning commission notes. in here?
So what we've done is we've deleted all those provisions with respect to the creation of the planning commission, along with the bylaws, left the zoning board of appeals provisions intact and just changed where it is in the ordinance.
Okay,
Yep.
okay. So all you're asking for is to start the process for a public hearing?
Correct.
What is it, 45 days or something?
15. So
15?
you have to give, you can set it whenever you want to set it. We have to provide notice at least 15 days prior to that public hearing because it still constitutes an amendment to the zoning ordinance. So for the public hearing purposes, notice will be published at least 15 days prior to that hearing. Then the planning commission will make a recommendation on the proposed ordinance to the township board. Township board then will consider that and take final action on that proposed amendment. After that, should that be adopted, then this will come back to you for consideration of bylaws then by the planning commission. I know we have a draft set of those. Hopefully we can revise those to the extent necessary, and the planning commission will have the sole authority to adopt those bylaws.
Yeah, because we spent a fair amount of time putting those together.
What, yes, well, I guess this leads a couple questions for me. What if there's conflict in those bylaws between the township board and the planning commission? How does that get sorted out?
So in what sense? Like, so, you know, the planning commission's, I mean, as long as it's not inconsistent with, say, for example, the legislative authority to create or continue the planning commission, then the bylaws govern probably all of those things that are already in your zoning ordinance. But I know there were discussions and tweaks to those bylaws as well. So I don't anticipate any conflict with the legislative authority. The only time that might happen is if let's suppose the township board adopted an ordinance defining what a conflict of interest is. The Planning Enabling Act says that's binding on the planning commission. But to my knowledge, the township board has not adopted such an ordinance. So in that case, then you have to define for yourself what a conflict is in your bylaws.
Okay. And I think that's part of where we've gotten tangled up in the past. I feel like maybe we need to sort out the bylaw part before we do this part, but maybe it just seems like we almost have the cart ahead of the horse, but maybe I'm wrong.
Member Bruno first.
So I'm gonna add two questions. I'm gonna switch the order. So the cart before the horse. So I kind of agree with that statement. So if we open the activity to strip this, we go rogue until something is adopted in the terms of a bylaw. Like, wouldn't an action say we're going to strike this and replace with this, like an is was? To strike something and not have something in place, how is that handled?
So there's a difference in the process, right? One constitutes an amendment to the zoning ordinance.
Yep.
The adoption of the bylaws is not.
So
So
I get that, but when you modify the ordinance by that action, we are
Stripping it out.
we're stripped. So there's nothing in place, correct?
well, so remember, right, you've got 15-day notice prior to the public hearing, then whatever consideration by the planning commission, ultimate recommendation to the township board, then time for the township board to consider and adopt it, and then even 7 days after publication before it even becomes effective. So there's a period of time in there where, depending on when you set the public hearing, you'll actually have, if I'm guessing, maybe 30 days or so to finish up those bylaws and adopt bylaws, which don't have to then go through a public hearing process or approval by the board. So they're immediate.
So you believe we can have a parallel path here?
Yeah, yeah. I mean, the timing we can work on depending on when you might set that public hearing. But, you know, suppose you set that public hearing for your January meeting or even your February meeting, we can work off that to get you, again, those draft bylaws where we left off with them and have the planning commission try and finish those up.
And see, I don't think we were waiting on the bylaws from you guys as much as our bigger problem was that we've had so many changes in members. Every time the bylaws come back to us, the newest member hadn't been part of the conversation. And so it reopened the discussion. And I think that's really just what needs to happen is all of us just need to maybe not all of us, but some of us need to read through them again and make sure that we're comfortable with them. But
So for example, I was the new member and I found it odd that we have a definition of what a conflict of interest is. I think the township should standardize on it. Like all the things that you are saying are pros to me are kind of cons, and maybe I'm looking at this backwards. When I read this, it sounded like it was a matter of opinion. It sounds like it can stay where it's at. But we can now, based on this new planning and enabling act, we can move it to that. But there's nothing saying we can't keep it here. And what the problem with keeping it here, the only thing I hear is like, well, we have to have public meetings, they have to have the board approve. I'm all for something this important to have many layers of approval. So can you comment on the downside of keeping it where it's at?
Yeah, so, well, two things. First, I'll mention the bylaws. So the Planning Enabling Act says in your bylaws, you must define conflict of interest, right? Unless the board has adopted an ordinance. So unless the board does that, you have to define it in your bylaws.
Okay.
These ordinance provisions are not technically bylaws because they're actually in your zoning ordinance. And so that's one reason why to remove them from there. They are established pursuant to your zoning ordinance without authority pursuant to the statute. Like bylaws do not constitute a zoning amendment. From a procedural standpoint, it makes it very difficult if you wanted to change those. Because again, you're talking about public hearing, recommendation, and ultimately the township board approving bylaws that pursuant to statute, it doesn't have the authority to approve or reject, if that makes sense. But you subjected them to that because of the manner in which it was adopted. So the Planning Enabling Act says the Planning Commission gets to adopt bylaws. It doesn't say subject to township board approval. And so you've subjected yourselves to that without statutory authority, at least from a township board perspective, of approval of those bylaws. So that's kind of when we look at municipal law, we look to statutory authority, okay? The statutory authority here separates two things. One is Zoning Enabling Act and zoning ordinance, zoning process versus police power ordinance pursuant to the Planning Enabling Act, which regulates then the process to enact both of those. One is separate than the other. They are distinct and different, which is why you don't see these types of ordinances encompassed within a zoning ordinance because they're two different statutory authorities for doing what the township does in terms of land use and zoning regulation, if that makes sense.
I think it kind of does. I guess I hear that, but I thought I heard a different story too. So I'm just trying to reconcile which one, because I thought I heard you say that some people leave it, some townships leave it in here and it's not best practice, but it works.
Well, no,
Then I thought I heard you say that it doesn't work. It's outside of their authorization.
that's right. So some townships have it in there. I don't think it's authorized by statute. They're not my clients.
Okay. There you go.
Member Engel?
Mike, Joe Engel, my question is more with a practical process here. Right now, the ordinance is for lack of a better term, our planning commission's governance, correct? It acts as our governance, and it is, the bylaws in a different context would be our governance documents. And I guess I wonder why we have to separate the process and leave a potentially, as these gentlemen have pointed out, a void between amending, stripping the planning commission completely out of section 23, and then going forward with what's going to govern us in the future. Why can't these be a parallel process where we go to work on the bylaws and rather than waiting while at the same time moving forward with the public hearing? Is there any magic to that?
Well, the only thing, so if I understand your question, separating out the creation of versus the bylaws, leaving the bylaws in and moving forward with the public hearing on the other part, is that what you've asked?
Well, I guess we would have bylaws in waiting, if you will, and have those ready to go when the ordinance is amended, stripping out the quote unquote bylaws regarding the planning commission from that ordinance.
Yeah, so you're right in terms of the governing documents, right? That the bylaws are that governance regarding procedure and process, right? For the planning commission. But I think that depending on when you set the public hearing, you should have adequate time in which to consider and adopt those bylaws. Again, remember, the bylaws themselves don't require a public hearing notice. It requires a simple meeting of the planning commission, motion to adopt, it passes. That's all that's required for bylaws. So we're trying to set up this track in terms of timing where we proceed on the public hearing part, and then we get to a place where, you know, township board is considering that amendment, and by then you should have those bylaws ready to go, I would hope.
And we would hope as well.
Yeah.
Yes, that's the point.
I've been hoping for 4 years though, and we haven't gotten them ready yet. So you're laughing, but this is the problem. And so I really feel that we should use this as a nudge to get those bylaws hashed out in detail at the next few meetings. And then however long it takes, maybe they'll be ready at the next meeting. And then initiate the schedule of the public hearing. I just feel like if an applicant comes in to apply for an accessory building, they've got a plan in place for that building before we schedule the public hearing. And I feel like without having that document to replace what we're taking out of the ordinance, I just feel that we're not following the process as well as we could. And then the other quick item I would say is this was one of the items, but there was a list of things that the planning director had been working on for amendments. Chapter 23 was one of them, but there were lots of other amendments too. We're only focused on this one right now, or is somebody been considering those other small tweaks or corrections and things that we have been talking about all year? And I feel like we're just not, I don't know, I guess this is progress. We're moving in the right direction. I just started venting there for a moment. I'm sorry.
No, that's all right. It is the only one that I'm working on currently.
Okay. Do you know if this takes away some of the current responsibilities that the planning commission has, or would allow them to be transferred to staff or the township board? I know when I was chair, we had some significant how would you describe it? Tension a bit with some of the township board members and some of the planning commission members related to how the former planning director had handled a lot of the items that the chapter 23 currently reads as being responsibilities of the chair. Approval of agenda, annual reports, things of that nature. I took some arrows because of that, because I just was leading the planning commission in the same manner as all the people preceding me had, but it was very specific in chapter 23 in detail as to what staff's responsibilities were and what the chair's responsibilities were. So does this, it was specific to the planning commission to get back to what that chapter said. And I think some of the township board members were very critical of that as well. They didn't want to see staff doing our job. Does this open up more flexibility for staff to do more of our job, or does it keep kind of more of a fence up saying we're in our silo and they're in theirs?
Yeah, it doesn't, at least as to the proposed amendment, all it's doing is taking out that authority for the creation of the planning commission out of the zoning ordinance. And eventually, I suspect concurrently, the board will be adopting an ordinance, police power ordinance, creating the planning commission, but within the same context as the Planning Enabling Act allows them to. The things that you're talking about are likely going to be encompassed within the bylaws.
Okay.
I'll give you an example, and this comes up routinely. Like, we're here tonight because the Planning Commission is going to consider scheduling a public hearing, right? But that process is not defined by statute. That is, I have clients who don't set their own public hearings, it's done administratively. So they'll get an application for whatever it might be where a public hearing is required, let's say a special use permit. And they just administratively schedule a public hearing, get the documents together, pack it together, make sure they're complete, and then the planning commission gets that, having had that public hearing already scheduled. Now you can do that because it's not prohibited by statute. But I suspect those things might be addressed in your bylaws. I'll give you another example. There's no legal process for canceling a special meeting or a public hearing. Not defined by statute, right? So who has the authority to cancel a meeting or cancel a public hearing? Like, for instance, you don't receive documents on time, but you've already scheduled a public hearing. Who has that authority, right? Those are all things that you likely will address or should address in your bylaws so that then that process is clear. Where the bylaws deal with the process, the creation of the planning commission deals with the legislative authority to create and continue a planning commission. So I don't know how else to put that to address. Hopefully I addressed that question.
No, I think you did.
Member Bruno?
So you referenced in that, so we're striking chapter 23. And I got the impression, apparently incorrectly, that we create bylaws and that's almost the replacement. It's a tit for tat or it's a swap. But you referenced it right there. So there will be a new, so chapter 23 isn't really replaced with bylaws. There will be a new ordinance establishing a planning commission.
Yeah, so two things. One is the bylaws will not go back into, so if you look right at the proposed amendment, we strip out everything with respect to the planning commission, leave the ZBA material in there because that's where it belongs because it's created pursuant to the Zoning Enabling Act. The township board then has to adopt an ordinance continuing the planning commission under its police power legislative authority. And then the planning commission must adopt bylaws, which will be a separate document, but it only has to be adopted by a majority of the planning commission members by motion. It's not a zoning ordinance amendment. It won't go in there. It'll be a separate document.
So let me repeat back what I think I heard. So chapter 23 is replaced by it covers two things. We're gonna have bylaws and a police ordinance that together kind of simulate or emulate what chapter 23 is currently doing.
Yeah, so when you say replace, just so we're clear, it doesn't go back in there.
Yeah, I don't mean to replace.
Yeah, but they are separate, yes, separate ordinances and a separate document for the bylaws. That's correct.
So I believe that answers your question. You would probably want to see a copy of the new police ordinance to find out what powers you're losing.
I would think all of that should be prepared prior to the public hearing.
Member Engel.
So the process is actually, there's 3 steps here. Number one, you put the ordinance up for public hearing, you strip out, you essentially eliminate the planning commission with that first act. It's gone. It's no longer enabled anywhere under ordinance or any other legal umbrella. Then we recreate the planning commission through through the police power that's granted the township board by the legislature. That's number 2. And then we create, because we are empowered to do that, the bylaws for the planning commission. Is that a fair summary?
Yeah, the only caveat to that I would say is that the planning commission, just by taking this out of the zoning ordinance, does not eliminate otherwise the planning commission. Pursuant to the Planning Enabling Act, it continues in effect, but the township board has to adopt an ordinance reestablishing it. So there's specific statutory authority, and I tried to go back and look for when that might have happened. There are deadlines established pursuant to the Planning Enabling Act that says the board has to reestablish the planning commission by July 1st of 2011. I have not found any authority doing that, and that is by police power. So what it says is that, and there's no penalty for it, but this is why we're engaged in the cleanup of this, is in 2008, when the legislature adopted the Planning Enabling Act, it said any planning commission created pursuant to the prior acts continues in existence, but that the township, in this case, would have to adopt a new ordinance reestablishing the planning commission by July 1st, 2011, I believe is the date. I haven't found any police power ordinance doing that. So the planning commission would still continue in existence, but it would be important for the township board to adopt an ordinance reestablishing its existence.
Is there a legal basis for the planning commission to continue statutorily once our existence, and put this in quotes, is stripped out of section 23?
Yeah, I think the Planning Enabling Act provides for that.
In what fashion?
Because we're only talking about process on how the planning commission was reestablished, right? So, for example, I'm not sure, and I can't locate how or when that the planning commission reestablishment, if you want to call it that, was included in the zoning ordinance versus a police power ordinance doing the same thing. Under either scenario, I would argue that the Planning Enabling Act allows for the continuance of the planning commission until the township board reestablishes it pursuant to its police power authority under the Planning Enabling Act.
And any actions that we took in that gap, if there was one, you believe would be protected?
Yes.
Second question, if I may. What is the scope of the police power enabling authority that the township would exercise in terms of what the planning commission could do and how they would do it? I mean, it's clearly spelled out in section 23 of the for the zoning appeals board. What would that look like for the planning commission? How far down would that go in terms of their conduct?
I guess I'm not sure.
Yeah, for example, what we see in the stripped down ordinance talks about when the meetings are held, how many board members there are, that sort of thing. Is that typically included in the reestablishment of the planning commission under this scenario?
Not necessarily when the meetings are, but certainly the configuration of the planning commission itself would be. So, yeah, I mean, there are a lot of those provisions that are being removed from the zoning ordinance that will likely be included in that police power ordinance pursuant to the Planning Enabling Act, right? So I don't know, like, the meetings themselves, when the meetings are held, those are generally established by the planning commission, not only because the bylaws will say that, but also because each public body establishes their own regular meetings under the Open Meetings Act and then has to publish notice of those meetings. So those things are generally, and I don't want to say you operate in a vacuum, right? Because there's meeting space that has to be,
Sure.
and you have to
Right.
time out those. But typically those things are done by the planning commission. But the meetings themselves, when they occur, are not necessarily included within the bylaws themselves, other than the planning commission, say at its first meeting in January, adopting a regular meeting schedule, right? So in the bylaws, you might have a provision if you wanted one that says, well, we meet on the first or third or fourth Monday of every month, right? At 7 p.m. Or you might just have, regular meetings shall be held at least quarterly. Why? Because that's what the Planning Enabling Act says. And then you could establish a regular meeting schedule at the beginning of a first year and publish notice of that regular meeting schedule. Not to mention you'd have a provision for special meetings, who can call those, which are also defined by statute.
Member Bruno?
So I think I'm understanding more. But so last week we tabled this and the discussion was, well, why table it? It's really easy. We're just going to strip this out and it's going to become its own separate document. Well, that's appearing to not quite be true. There's going to be two new documents. I don't want to use the word replacement because it's not going back in. I get that. So there's going to be two new documents, and it's going to be you're going to divvy up the current chapter 23 as it applies to the planning commission. Part of it is going to go into police ordinance and part of it is going to go into bylaws. Is that correct?
Well, I'll let the planning commission decide what's in the bylaws, but
Oh,
yes.
But it's going to be divvied, right? There's parts of it are going to go into a police ordinance and parts of it are going to go either to maybe it's three ways. Parts of it are going to police ordinance, parts of it are maybe going to the trash can, and parts might go into bylaws. Is that fair?
I would say this, the organizational part for the planning commission is created, adopted by the township board. Everything else procedurally decided in the bylaws by the planning commission.
Okay. Being the new guy, which I've already identified, Can someone mark up what chapter 23, all this in yellow would most likely go into police ordinance, all this in green, you would probably keep as a best practice. All this in red is redundant and no good from your legal perspective, throw it away. And then magenta is stuff you're missing because under the Planning and Enabling Act, it's slightly different than the Zoning Enabling Act, and you should have these things in, such as some of the things you've mentioned.
Yeah, we could certainly mark that up and give that
Very
to the
helpful.
planning commission.
I think that would be helpful, because I'm confused as to what's going where, and it sounds like our current bylaws might not have everything it needs because it was written on the assumption it's partially within an ordinance. Is that
Well,
correct?
I think before the legal counsel had recommended that we leave part of it in chapter 23 and that we strip most of the stuff that we can decide out so that we left the bare minimum in chapter 23. But the bylaws came out and then we had a separate conflicts, code of conduct, I think is what we had. And I think if I remember right, in March, the conversation took a U-turn because there was discussion about whether or not that code of conduct should be decided by us or the township board. What I'm hearing now is that because the township board doesn't really have that, it's up to us to create that, but it just, yeah, I don't know. It seems like we keep flip-flopping back and forth.
Sounds like maybe we already have it. I didn't realize we were leaving part of chapter 23 in, so the part we're leaving in probably already.
Well, but what he's saying now is no, they'll take it out and then do the,
The
yeah,
part we're leaving in is now going to put up the police ordinances.
possibly. I don't know. That's, I guess why I liked your idea of getting something that shows what's going on. I would like to see his recommendation of what he would recommend the township adopt as the policing powers document. I guess
Yeah,
that would
could
be.
you have you seen our proposed bylaws? Could you take this, our
The staff
bylaws
has.
and the police and
Yeah.
create a roadmap of these would be great documents that have synergies and can coexist and not step on each other?
Yeah, we have drafts of them. I just didn't have an opportunity to review them yet, but I know we have, because Leslie was working on them. Leslie's out on maternity leave, but they're on our system, they're filed electronically, so.
Personally, I'd like to see us review the bylaws before we schedule a public hearing on this issue. Because it's been a long time. I don't
Yeah.
remember past 3 months, exactly all the stuff we talked about.
Yeah, I feel real uncomfortable just pulling it out. I think that my opinion, the proper path would be the township grants the creation. After that, we submit the bylaws. After that, then we pull it out of 23 and move things around. I think the cart before the horse is a very appropriate. And because there's things that are going to slow us down, and guess what? Now we haven't had this approval, we haven't had the bylaws done, and we're kind of operating in the wind.
I just don't want to schedule a public hearing on something that's not really firmed up yet.
That's what I'm saying, like,
It's a little
all this
deceiving
other
to the
stuff should be done first. Once the township is given the approval, once we've approved the approval of the creation, okay, we've been created. Here's the new bylaws on the new creation, boom, okay, now we set the public hearing, now we pull it out.
You can't approve, we are not allowed to approve bylaws the way the law is currently structured.
Well,
We could have a draft.
We can
ready.
prepare a draft, but we have no authority the way 23 is written and the way the law's written to actually enact.
It's not,
bylaws.
it's not true.
I think you could.
According to the legal opinion, we just couldn't say anything in the bylaws that opposed what was written in chapter 23.
Yeah,
If chapter 23 said you had to wear yellow clothes every day, the bylaws couldn't say you're wearing blue clothes. Chapter-
Nordhook,
You have bylaws. I think you can continue to use those. All we're gonna do is set a public hearing. We're gonna be a month and a half. We needed to get in here and do our job. I think about 85% of the bylaws are already written. All we're gonna do is tweak them and make some additions to it. I don't think that's gonna take 8-9 months.
I would agree with that last statement. But
member Bruno.
I have a question. Scott surprised me, one of the previous things that he made a motion that came out of left field. I'm not under the impression that there isn't something else going on here, so I'm gonna just throw it out there. there's lots of rumors in the background. So one of the rumors is there's a need to right size going from 9 to 7. Is that the urgency? Because what I'm hearing, and you can repeat back if I'm incorrect. The Planning and Enabling Act was 2008. You had until July 1st of 2011. So we're 12 years delinquent. Is that correct? Yeah. So I'm questioning why there's a fire currently. So clearly, I don't think there's a fire because the house would burn down in 12 years. So my question is could we make a motion, since apparently it's in the chapter 23, the 9 versus 7, if someone was brave enough to right size and get the 7, would that scratch the itch so we can do this on a timeline that gets a good work product?
Well, I'm not sure it's going to be a bad work product,
Okay.
but I want to go back to something Commissioner Rowland said, which was the timing of it. So yes, the township board tomorrow could consider an ordinance creating the planning commission. They just have to have 2 readings, right? For any ordinance, police power. And they could adopt that. And what if the planning commission then doesn't amend the zoning ordinance? Then you've got a conflict possibly between this new police power versus the zoning ordinance, right? And so that creates a problem procedurally. And so it's actually process-wise better to do these concurrently, which is how it would work, where the planning commission has a public hearing, makes a recommendation, township board, being the legislative body, has final approval of any zoning amendments, right? So you make a recommendation, they're not going to adopt that, if at all, until and unless they have that police power ordinance, because otherwise it would leave them in a space where the planning commission might continue, but they still haven't complied with the ordinance. Okay. That's the first thing. The second thing is, I suppose, and I don't know about the fire, but I suppose the township board could take a different approach too, which is send a proposed amendment to the planning commission. They haven't. I think this originated through administratively. Send a proposed amendment to the planning commission, and the planning commission would have to schedule a public hearing and make a recommendation because the board's like any other applicant. So one way or another, I suppose we get to the same place. I think that we should be looking at bylaws to remove them from there to deal with the process issues separate from a zoning requirement where it just does not belong there for a lot of different reasons. Most of which is statutorily, you've given away authority to the township board for approval of bylaws that they don't have approval for. At least statutory authorization. So, but process-wise, as long as we get to the same place, I'm not sure I care at this point how it works, as long as, Scott, to your point, it's a nudge to get it done. I mean, if we're 4 years down the road and we can't get to bylaws, that's an issue.
Right? And
We'll move faster than that.
I hope so.
So backing up about 5 sentences, you would not counsel the township board to move ahead with stripping section 23 unless they had a police powers enablement for the planning commission ready to go.
That's right. Yeah. But the process between now and when the board gets it, got to be at least a month, maybe 2, depending on timing. So.
Have you worked on putting that together yet? The
Yes.
enabling piece?
Yeah. And I've done this, I don't know how many times.
Sure.
So, yeah, so I've got like, yours is specific to at least the zoning ordinance, stripping out or deleting those sections to the planning commission. But I've probably drafted 10 or 15 ordinances creating planning commission since 2008. And to your point, you'd be surprised how many jurisdictions have not done it. Okay.
So you have already created that I hate to use that, it sounds ominous, but the police power document for the township board, which will provide an existence for the planning commission?
Yeah, I have a draft. Yeah.
But they have to approve it, right? I mean, they have to.
It sounds like we're doing a lot of good things. I think there's just apprehension of the order and the sequencing.
Yeah,
Professional project manager here, so I want to, waterfall and it's got to be done right. If we're cleaning up, have you made a recommendation to the township board to have a conflict of interest township wide as opposed to us creating our own and the zoning board of appeals creating their own and everyone flying by the direction of the wind that their group sees fit?
I haven't, but we certainly can. I did one not too awfully long ago for another township, charter township client of mine, where we made that applicable to all the township board, the planning commission, and the zoning board of appeals, and defined it the same way. So there was no gap in terms of how people viewed conflicts and when they needed to recuse.
Is that the way to go, in your judgment?
Well, I like it better, right? Because it standardizes that. You don't have, like, for instance, absent a definition, there's no conflict of interest standard that applies to, say, the township board, except for maybe your common law definition on what a conflict might be, right? Pecuniary gain from a decision that's going to be made. Well, in some cases, we broaden that out. Now, so, like, for instance, there are some jurisdictions that will say, well, if you own property within 300 feet from an applicant who has a matter before the planning commission, then you need to recuse yourself. Well, that's not statutory, that's just made up, okay? And so you can do that, you can define it that way if you'd like, but you have to, I suppose, consider the unintended consequences of that as well. In larger places like Cascade, it might not matter as much. In smaller rural community with large parcels, it matters. And so, it just depends on how you want to, or how the board would define it in that context.
I would appreciate it, because again, being a new guy, I read our bylaws and hopefully I'm not offending anybody here, I don't know who wrote it, but the section on conflict of interest was horrid. It basically said, if you can gain any interest, I don't know the exact words, but it wasn't really written well. And I think it should be standardized, because I would object to what our current one that we're proposing. I have an interest in pickleball. If I vote on something where there's a new pickleball court, I have a gain. Is it a gain more than my peer citizen within the township?
There's another.
Nowhere to go with that.
One more quick in here. There's a document that we played with last March. It was also in the packet, and I think it was March 6th. That was something called Cascade Charter Township Planning Commission Rules of Procedure, again, specific to the Planning Commission, nobody else, which is where this is defined. And those were supposed to be actually pulled into or incorporated by reference in the new bylaws. And which I thought was somewhat of a messy way to do that. This is just one reason why I think this whole packet, in terms of bylaws and how we time this, is pretty critical. It deserves some time.
Yeah, and so typically, you're right, it's probably not the way to do it. It would be to incorporate those into your actual bylaws.
Agreed.
Yep.
Agreed.
And then the only other board that has rules, not bylaws, is the zoning board of appeals. They can adopt rules. And so, like, for instance, unless it's in your zoning ordinance, let's say there's an appeal to the circuit court from a decision of the ZBA. That time frame for an appeal is governed by general rule of the ZBA. And the statute doesn't define what that means. So we often have rules of procedure then for the ZBA to define when those appeals are perfected or when they're timely, because without it, it's a guess. Like, there's no stated time limitation then on an appeal.
I have a question. You said you've done this a bunch of times. Have you ever had an occasion where, and please roll with me a little bit,
Sure,
where they've stripped out the 23, right? Chapter 23, and then the board has not given approval for the reformation of the planning commission?
No, but I will also tell you that I don't have one client that contains it in its zoning ordinance. And we must have 100 municipal clients.
Good to know. Number.
So, yeah, I don't think we have the authority, but I completely agree with Mr. Engel. And that was back to, I was the dissenter at that meeting back in March, because we were gonna leave part of it in chapter 23, then we're gonna have bylaws, we're gonna have a code of conduct and the layers. I would love a standalone document that covers it all, and it even doesn't, it doesn't even mention, conflict of interest, because that's covered elsewhere. Let's keep it simple, short, sweet, precise, not referencing the other documents.
With regard to bylaws, and let's just say we have 100 bylaws that we're looking at, can we, and hey, these are the 80 that we're gonna enact right now, these 20 we're gonna work on in the next. I mean, the bylaws don't all have to be done complete, right, in one shot, right? We can do it if there's, Joe, no, yes?
Yeah, you don't want to piecemeal those. You want to get out and get it done.
Well,
That in my experience, but
Well, I will say, this is the benefit of having bylaws, because imagine, if you will, you were going to amend your bylaws now. Public hearing, recommendation to the board, decision by the board on bylaws that you have the authority to adopt. If you adopt bylaws as a standalone document,
Yeah.
just setting forth even the bare bones, right? In terms of procedure and meetings and who has the authority to call them, et cetera, et cetera. You can amend those at any time by simple motion and vote at any meeting without notice.
Okay.
And that's the benefit.
Yeah, which is good. Okay.
So even if you don't like them after a while, you can revise them.
Member Reese?
Okay, let's see if I can take some more arrows here. A couple of questions. One, you guys were talking about the size of the planning commission. Do you have particular opinions on how municipality gauges how many people sit up here?
Yeah, so it's a good question. And my clients run the gamut. So for example, I represent City of Cadillac, and the only reason why I mention them, they're of similar size, right? About 15,000 people or so.
Okay.
They have 9-member planning commission, but it's constantly an issue for them. Like, they can't get people to come. There's always people absent, right? And then people don't want to vote on things until the full planning commission is present. And so it's created some issues. My own personal opinion, when I look at our clients and what they do, is I don't know why the planning commission ever outnumbers the township board, just as a matter of course. Now, having said that, the planning commission is supposed to be representative of the community itself, right?
Mhm.
And so typically you try and find, geographical differences in where people are located and the representation of those. So as long as you do that, you could do that with 5, 7, or 9 members. It just depends on how your community is made up and how that representation unfolds.
If a planning commission is larger than a township board, that really doesn't create an issue though, does it? Because I mean, it's planning commission and the township board are two different entities. I mean, if we have a fire department that's larger than the township board, it's irrelevant.
Yeah, it's not statutorily, there's no set number other than 5, 7, or 9.
Okay. Then I guess my other question would be, that's interesting that you mentioned with Cadillac, because the way our planning commission arrived at 9 members is because when we had 7, they were having trouble meeting quorum sometimes. And so they went to 9, and since that happened, there hadn't been any more issues until we lost Wendy and we didn't meet quorum, ironically, at a meeting this summer. I think was the first time in at least 10 years that we had a meeting canceled because we didn't meet quorum. But with respect to and this is a little bit in the weeds here, but it relates to some of this. A couple questions about the ZBA that I'd like to take advantage of asking you on real quick. They're pretty easy ones, I think. If a matter is before the planning commission, such as an accessory building, and the ZBA has ruled on a variance for that particular building.
What happened tonight?
I was not going to bring that up, but is it appropriate in your mind should the the ZBA member who voted on that case at the ZBA level, should they be absent when the planning commission takes up that matter? Is there a conflict there? My understanding is that there's a conflict there if it goes the other way around and there's an appeal from the applicant to the ZBA, then the member sitting on the ZBA who saw it at the planning commission should sit out and the alternate should sit in.
But see, I don't agree with that because it's good for that person to relay the information that was said, which.
Right, but the ZBA is the last stop for somebody to appeal before they go to court. And so it's very critical that the township get that right and it not be, that it be viewed as an impartial review. that it
Right,
not-
but you're also that
Taint.
representative that says, listen, this is why we shot it down. This is why it's here. This is the discussion that was amongst board members.
I
and the
hear that.
concerns-
I'd like to hear his, I'd
Okay.
like to hear his opinion.
Mike?
Well, so this, I think arose out of an attorney general opinion because the attorney general considered it a due process problem. Where you have the ZBA as a quasi judicial body, right, ruling either on appeals, mostly appeals because variances are administrative, right? So on an appeal where the planning commission member had sat on that and now sits on the ZBA, the attorney general thought it was a due process problem to have the same individual sitting on both, ruling on both, right? Particularly if you are now deciding an appeal on your own action at the planning commission, right? That's the due process problem. The other way around is likely not a problem because it's no longer a quasi judicial body. That is, ZBA grants a variance in this case, right? Administrative. Then it comes to the planning commission on this application for a special use permit, say, right? There's probably not the same due process consideration there because one, the ZBA wasn't sitting as a quasi judicial body on an appeal, but more as an administrative body granting a variance. And the planning commission is also sitting as an administrative body on the special use permit. So it likely doesn't flow backwards, but I'm not sure that there's any cases addressing that specific issue.
What if the planning commission voted down the same item that the ZBA created the variance on and the applicant appealed it back to the ZBA?
So
If the ZBA issued a variance on it in the first place, does that put them in a difficult spot? Should the process have gone to the planning commission first and then to the ZBA? Because it seems to me like we've created a little bit of a discrepancy by having a person go to the ZBA first and then come to the planning commission and ask if they can build the building that the ZBA gave them a variance on.
Yeah, I don't know that one is better than the other, except if you get, like, for instance, if you had the special, so the variance and the special use permit are two different things, right?
Right.
Variance is just a variance from size, setback, whatever it might be, a dimensional issue. And the special land use permit itself is related to the land use itself, right? What is permissible under your ordinance for a special land use, okay? So they're two separate things. And so even if they appealed that to the ZBA now, a denial, say on the special use permit, one, it has to be authorized by the ordinance, and I'm not sure it is, because typically special use permits are not appealable to the ZBA. Sometimes they are. But let's suppose it's appealable. Then that member who sat on this body hearing or voting on that issue would have to abstain or recuse themselves at the ZBA, and you would appoint an alternate to sit in their place.
Okay. Would it be your recommendation that those type of situations, like if somebody's looking for a variance for a accessory building, a special use, would you prefer to see them get the special use from the planning commission first, or would you prefer to see them get the variance from the ZBA first, or do you not care which direction it goes? Because we've had a few of these come up lately, and I want to make sure we're doing them in the correct order.
Yeah, and I suppose the order itself ultimately doesn't matter, but I can tell you that as a matter of course, let's suppose you approve the special use permit. subject to getting a variance from the ZBA. That puts a lot of pressure on the ZBA to grant the variance. The same might also be true, but I don't think as much. Where you grant a variance, when you grant a variance from the dimensional things, right? Height, setback, whatever it might be, doesn't lend itself to putting pressure on the planning commission to say, oh, well, this land use that's only permitted by special use permit is appropriate,
Okay,
if that makes sense.
yeah.
And I'm not sure, look, I'm not stuck on that. It's just one way or another, you get to the same place where another public body might feel compelled to do something based on the other's approval.
So I hear you're comfortable in either way, including the way we're doing it. It seems like
Yeah.
it's okay. All right. That's all I wanted to know.
Right?
Thank you.
This is way out there, but it actually just was before us. So the ZBA
Tonight.
allows you to be closer to the setback, grants the variance on the setback. That same building is coming to us because it's exceeding our
8:30.
832 square feet. So inherently it's bigger, it's taller, it's wider. And now it's closer to the property line. The combination creates an issue. But are we allowed to look at the combination because the variance has been granted, or are we supposed to block that out of our minds that the combination of it? The variance has been granted, so we can't consider that anymore?
So I want to make sure that I understand it. So, variances deal because the Zoning Enabling Act eliminated, for the most part, use variances for townships, right? They can't grant those, ZBAs can't. So we're always talking about dimensional variances, right? In most cases, we're talking about two things. One is size, square footage, or encroachment into a setback for some particular,
So this is encroachment into a setback,
okay?
but their size is such that's triggering a special use permit. So they went and got the variance. They come to us, and anything in excess of 832 square feet for an accessory building is by definition a special use. So we're sitting here going, wow, it's 5,000 square feet, 20 stories high, and really close to this property line. That combination seems bad for the neighbors. But the variance has already been granted on being close to the property line. So are we supposed to block that out of our minds because the variance has already been granted? Or can we consider that in combination with the size and cite both as our reason?
Yeah,
denial?
so for example, the variance only allowed a setback infringement,
Correct.
but was not for size, correct? So under that scenario, you can consider, you can put it where you want to put it, but we're going to limit the size to whatever you want to limit it to pursuant to your authority on the special use permit side, right?
But I would not want to say, wow, it's too big. You've gotten a variance and it's too big to be that close to the property. They've given you the variance.
I think you could say.
I could say that. I could state those in combination.
Yeah, I think you could say, look, you might have gotten the variance on the setback, but that doesn't bind the planning commission to allowing a certain size.
Okay.
It's two separate issues.
Okay, but we can cite them together.
You can consider both.
You can consider.
You can consider, yeah.
The one is still on the table.
And now that you have the answer, you can no longer refer to yourself as new.
Yeah, you've been here longer than 6 months. That
Good luck
doesn't
with
fly anymore.
The interesting part, I suppose, would be and I haven't looked at your zoning ordinance on that issue, but the interesting part would be if they applied for a variance to the ZBA on the size and the setback and said, we're limited to
think they can do
800 some
size.
square feet.
Yeah,
It's just
I don't think we
setback.
do. Yeah, just setback, yeah.
Interesting.
Yeah, I'm not, I'm not gonna look at it, but most like dimensional variances are aimed right at those things. Size, setback, height, bulk, right? That is by definition dimensional.
Yeah, we got a whole other issue. What you're saying to me makes perfect sense, but our ordinance basically says anything bigger than 832 is special use permit.
Yeah,
So there really is no upper bound.
And so if that's true, then too, that should prohibit an appeal on a special use permit to the ZBA. But I don't know if it says that or not.
I do agree with Scott Reese in that I think issues should come before the planning commission before they go to the ZBA. And I'm saying that as a member of both myself.
And who establishes that? Back to the establishment of, is that a procedure, a bylaw, a statute, a flip of the coin? Who's in the office on a given day?
Police powers.
That's just a function of the zoning ordinance and where you file an application first. Like I could tomorrow file an application for a variance for the ZBA and say, yeah, I want to build an accessory building, but I need to encroach in the setback for a practical difficulty, right? And so this is kind of germane to the planning commission because 2 weeks ago, I argued a court at the Supreme Court and waiting for a decision, and it had to do with dimensional variances. Now, in that case, it had to do with the Airport Zoning Act, but the problem is the Court of Appeals construed it to also be applicable under the Zoning Enabling Act by saying that practical difficulty now is not related to a characteristic of the land, but rather a practical difficulty is personal to the applicant. Well, that's a terrible decision. Because if that's the case, I can establish a practical difficulty in any
Anything.
circumstance
Yep.
I want.
Ask them.
And so I don't know how that's going to turn out, but I'm hopeful. So
Member Nordhook?
So in the essence of time, Mike, would you recommend that we make a motion to amend chapter 23 of the zoning ordinance to remove the planning commission references?
well, I would make a motion to set a public hearing. I'll let you guys decide when you want the public hearing. But I don't necessarily have an issue with, whether it's January or February. We just want to make sure we've got the timing right too, to get a concurrent ordinance to the board too. So,
The concurrent ordinance being the police power establishment of the planning commission.
correct.
I noticed the township board last week approved a meeting schedule for the year, but it shows that we're not meeting the first week in January, but we're meeting on the 15th. But Chair Nordike had previously said he didn't want us to meet on Martin Luther King Day, I thought, and that we were going to meet the other week. So I didn't know. So are we meeting in January or are we just not going to meet at all?
I think we could meet once a week until we got this bylaw thing straightened out. You know how it is.
Yeah.
This is gonna go on for months.
Right. No, I could see us getting that done. I would be in favor of seeing the draft bylaws ready and the police powers and then put it, and then set the hearing date once that's ready and use that as leverage to keep us on task to getting it done. But
Meet in the back room at Cascade Roadhouse. We'll get this thing done in an hour.
You
I
can,
think it's pretty much there. I just think
you can do that if you notice it appropriately. So.
Yeah. But that's what I would do. That's what I would support is that we review the drafts and then set the hearing so that we're showing the public what we're proposing as opposed to setting a hearing to strip it without the replacement ready. But that's just my take on it.
I would second that motion, but I can't do that.
So
So
clarification, reviewing what drafts? Are we requesting of?
I think at this point, it sounds like we need to have someone, whether it's staff or Mike's office, but somebody needs to, it sounds like, include those rules of conduct that into our bylaws, the rules of conduct being what was discussed at our, I believe, March 6th meeting, if I'm not mistaken.
I
March
thought that we
9th,
were going
March
to take
6th.
those out of the bylaws and make those
Separate.
township wide. I thought that's,
Well, we can't make them township wide. The board has to be township
You
wide.
can't write the rules for the board. You have to
Absolutely
write
not.
the rules for the planning commission.
You're
They
talking-
write their own rules.
absolutely, but I'm simply saying if the township passed its own rules of conduct, we don't need to include them in our bylaws.
Yeah, and I don't think that they would go so far as to say, so the township board has the authority to adopt board rules. What we're talking about is an ordinance that defines what a conflict of interest is for all of its other public bodies, the Township Board, Planning Commission, ZBA. So that part in your bylaws, then you could simply refer to the ordinance that adopted the conflict.
Got it.
Yeah.
Okay.
Right. I guess I think that needs to get sorted out.
But
That's,
you've done that for other clients. You probably have a
Yes.
template for that, I assume.
Yes,
Pretty easy to do.
yes.
I think you put the meeting for first part of March and that puts a time clock on us and so we get it done. Cause I think if you don't, yeah, I don't think if you don't put a time clock on us, I think just it's not a priority.
Goal.
Yeah.
to all this.
You don't think we can do it before then?
I was just trying to give us a little extra, but
with our regular meetings, well, that would only give us 2 meetings if we go by what we had done this year.
it gives us January and February.
Because they omitted the first meeting and that's.
While they're debating, can you give me the timeline again? So
Plus we
we,
do a special
Meet
meeting.
several meetings. I meet at least once a week.
we set a hearing date. Public comes in, debates, cutting that out.
Gives you public comment on it. Yeah.
I'm sure. no,
We then, and then take me from there.
Yep. So
On both
after
ordinances.
the public hearing, at that meeting or a meeting thereafter, there's no set time limit. Then the planning commission ultimately makes a recommendation. Think of it this way. It's like any other zoning amendment, right? So planning commission then makes a recommendation to the township board. Township board then, because you don't have a county planning commission, township board can take that up at its next meeting, but it still must have 2 readings because it's an ordinance adoption. So there's an introduction at one meeting, adoption at the following meeting, typically.
So that would still give us another 30 days in case we ran over on not getting the bylaws
Well,
finalized.
So you're saying set the hearing for March 1st?
Or whatever, yeah, like the beginning of March.
Meeting.
Hold on. All the way through April and then to May?
So I think that would give us January and February to get the bylaws done. If we don't have the bylaws done, we do the public hearing in March and then we do the recommendation to the board. The board would have 2 readings, so I would think the board would, and I'm just extrapolating here, board would probably approve it April 1st or the beginning of April. That would have given us another 30 days on the bylaws if we need it. That's just my thought.
what I thought I heard him say is kind of cool. I guess the question, is the public hearing just on, are they gonna give us constructive feedback on our proposed new bylaws? Or are they just giving us, then we can have the meeting, we could have the meeting tomorrow. We don't have to, we can then wait to make a recommendation up to the board. So why don't we take that as an input? Why don't we get, if,
Because nobody's gonna show up.
okay, just check the box. We can have the meeting, so it's behind us. And then it's in our hands to move it up to the board. Is that correct?
Schedule it.
So why not be preemptive and just get it done?
Well,
Anything for the
Schedule
public
the
to
first meeting in
react to.
February.
There's 2 different tracks here. There's the bylaws that will eventually govern the planning commission, which is something we need to get done and work on to get them in place. But the other 2 ordinance changes are what you're talking about that have to go at the same time for public hearing and then through that process.
yeah, except that only one of those is subject to the public hearing.
Yes.
So the zoning amendment, stripping out those provisions out of 23.
Yep.
That's subject, because it's a zoning amendment, that's subject to a public hearing, recommendation by planning commission, township board consideration and adoption. The other one is police power ordinance, continuing the existence, township board, 2 readings. So we would time that out because those are both going to require 2 readings at the township board level.
Okay.
So those would be concurrent, introduction and then adoption at the next meeting.
And on a parallel track, the planning commission works on getting the bylaws ready to go with your help and tweaking these rules of conduct.
Correct. And the zoning amendment would not become effective until 7 days after notice of adoption of that township ordinance. So it's 7 days after that notice of publication, which has to be published in 15 days. I know all of this is a kind of a blur, but so township board considers the zoning ordinance amendment. They also consider the adoption of an ordinance creating the planning commission. That ordinance would become effective upon the effective date of the date the zoning ordinance amendment becomes effective. which
Okay.
must be, the notice of adoption has to be published within 15 days of the approval of the board. And then it becomes effective 7 days after publication.
Okay.
So that's why the timing's a little tricky, but we would run those concurrently.
And we could meet as a planning commission and vote and say that when those two
30 days.
go into effect, the zoning change and the ordinance,
The clock.
our bylaws become effective.
That's correct. Yep. So the bylaws themselves are the easy process. I say that easy in terms of the process for adoption, which is simple majority vote of the planning commission to adopt bylaws.
I'd like to make a motion,
I have a question real quick.
but he can make.
Rob. So a little while ago, earlier, I'm addressing you, Alan.
Yeah.
You mentioned, and several other people also agreed that you know, in a situation where you don't want to like sell your house before you buy the next one, right?
Mhm.
But then maybe like half an hour later, I felt like you also then said, well, we need to set a timeline to make us get motivated to get going on this. Like, are those not two sort of opposite opinions on the same? Did you change your mind?
No, we got to get the bylaws done and we got to get them approved, right? Because if we can, like member Bruno said, we can delay this anytime we want, right? We can set the public hearing, listen to the public, and we could wait 6 months to recommend this to the board if we want, right? But
Is that accurate?
Yeah, there's a point in time where it likely becomes stale,
Right.
but it has not been established either by law or by statute.
Right.
So
I guess my feeling is all this sounds like we're moving forward in the right direction.
Mhm.
I have no, objection to any of this concept. But I do agree with what several people have mentioned earlier that I don't want to assume that we're going to get something done in 6 weeks that might take us 18 weeks or something like that for whatever reasons. I mean, if we have to cancel a meeting, then it's not going to, I don't like creating a deadline that doesn't need to be created. I do like the idea of having everything ready to go as much as possible before, we've
here's my
worked our
concern,
hand.
right? My concern is we've been working on these bylaws have been available for
4 years.
4 years,
At least 3 years, because
3.
I was chair
okay?
for 2 years and we started working on then.
If
Chris
we-
was chair for 2 years.
If we don't put a clock on it, right, other things will come up that we will prioritize above this, right? I think we put a clock on it. It forces us, like Timmy said, all right, so we just might have to meet once a week. Fine. And we just bang it out, get it done and move it out, get it off our plate. I mean, it's been stagnant and I think it's stagnant because we haven't put a clock on it.
Okay, I don't disagree with that concept. at
Yeah.
all. But I don't, so we're not talking about setting like a note and creating a deadline for ourselves that we might not be able to meet.
But if we don't meet it, it's not a big deal, right? Here, that's,
I don't know,
no, but it's not. We get
but then it's not a real deadline.
well, it's at least pushing us in the process, right?
Deadline. It's keeping it on the calendar.
Yeah.
I think that's our biggest problem.
I think I agree with everything you said, except for it was a lot of we. I think it sounds like the we has been happening for 4 years.
Hmm.
And I don't think any of us, well, one exception. There's one lawyer, but we don't play it on TV and we aren't lawyers. Why don't we stop the we? We have an outline, we have a skeleton. And it's 2 separate documents. Can we have the law firm come back and say, they're subject matter experts? They can take what we have, they'll get our gist. This is what we recommend. We cleaned up your redundancies, we consolidated into one document. We pulled out the conflict of interest because we're going to propose that the township do this at the board level. Here is something clean. Throw some darts at this, but there should be far less darts than throwing it at what we have now.
You're talking about the bylaws.
The bylaws. Give that to somebody and have them come back. If we're doing it individually, is that the best use of time?
Mike, your thoughts?
So my thoughts are your bylaws should be the least controversial document you have.
Yeah.
I mean, they really are. They spell out basic membership requirements and procedural issues that might not be covered by statute that you want to use, like, for instance, who has the authority to cancel a meeting, right? But those are simple things that shouldn't cause much controversy. That's not always the case, and I recognize may not be the case here. But they should be the least controversial document there is, only because you can change them at will. If you don't like them,
Might be least controversial, but it's been months. I don't think our proposed bylaws say who can cancel the meeting.
Do you have other drafts of bylaws that we could?
Sure.
That we can
well,
review?
we worked on yours. I mean, we.
Yeah, ours
we-
are ready. I think the only concern I think was, well, I think that
Say-
it was the rules of
if they're ready,
conduct
then
being
they
a
can-
separate document, I think was the concern.
At one
Right.
of the meetings, you said we're waiting for legal to look at them.
Well, I did some reading though.
They're all ready to go. We're just waiting for law firm to look at it. So I'm actually taking your words and saying, let's have law
Yeah.
look at it, but I'm getting pushed.
No, I think that it should, but I think that it had more to do with the rules of conduct side than the bylaws side, if I remember right. I know Treasurer Kristanj had some, and I think you had some concerns related to those.
I had concerns
Or
that
maybe,
there were three.
I might be
documents.
blending meetings together.
Some stuff was in triplicate and it conflicted.
Okay,
That was my problem. You can't in three different spots say three different people can cancel. Which one supersedes the next? That's why I'm saying, send it over there, have them clean.
great. Have them review it and then we can rubber stamp it.
There you go. I mean, if you think you've worked on it for months and months, if not 4 years.
I was content with the first version.
And they're already written.
But I think, to Joe's point, to the extent you have rules of conduct that govern the planning commission, then we ought to just include those in your bylaws. Now, I'll take a closer look at that aspect of it to see if we can consolidate everything we need to into the bylaws. Because that's where it should be.
I think that was the hiccup, I think, was having them brought in, and I could be wrong on this. But I think that's where the discussion went. I think somebody, and I could be wrong on this, I think I said the treasurer a few minutes ago, but I don't know if it was Wendy or not, but somebody wanted them included in the bylaws and somebody just, I think, wanted them to be separate, or wanted the township board to take them on so that they went down to all the committees in the township, so that the Parks Committee and the Planning Commission and the ZBA weren't all working on their own versions of rules of conduct, that there was a standardized set, but I could be wrong on that.
Well, let's have our attorney put together the bylaws with the rules of conduct included. And then send those to Madison, who can then distribute them to us. And I suggest we meet on January 15th.
Well, wait a minute, is that gonna be done by then? Because if it's not
I
done
think
by
you
then,
can have it done by then. Almost.
Yeah,
halfway.
I should be able to have it done.
If we could have all three of the documents, I mean, you've already done the proposed
Yeah.
amendment on 23 and then have the reenactment for the planning commission and then also the minutes by the 15th, is that?
Yeah, I don't think, because I think, and Leslie's on maternity leave, but she's been checking her email, because I'll check with her. I know we have it, and so it shouldn't be that big of a lift to get those bylaws in a shape where you can review them again and tell me what needs to be changed, and we can get those revised.
Member Nordhook?
Yeah, I think that'd be a good idea. It seemed to me there was another issue with the rules of conduct or something with the elected officials.
Yeah, so, and I'll take a look at them, because typically you'll have the board can adopt rules, and typically those board rules apply to the board. The conflict of interest, and this is from the Planning Enabling Act, right? And it says, unless the legislative body by ordinance defines conflict of interest for the purpose of this subsection, the planning commission shall do so in its bylaws. So when we talk about conflict of interest, and we're not talking about, rules of conduct, which may be that just rules versus an ordinance defining what a conflict is. And that's what the statute requires in terms of having that applicable to the planning commission, say the board and the ZBA. But I certainly can recommend that so that it's across the board the same standard on all of those public bodies.
Well, I'd like to shoot for January 15th, if that's possible.
Well, I'd like to make a proposal then that we shoot tentatively for the first 2 weeks of March to hold a public hearing on removing these items from chapter 23.
We meet on March 4th,
March 4th, okay?
if you'd like to set that date,
Sure.
or we meet on March 18th.
Okay.
So
Got a motion
just-
on the floor.
Well, this is clarification over here.
Yeah,
Just procedurally, I think there's still a motion on the floor, but I'm not sure there was support. So I just want to make.
yeah,
sure.
we haven't gotten that far yet.
We're getting there.
No,
Separate motion.
He had-
Oh, separate
He
motion.
had made a motion, Timmy had made a motion early on.
correct.
I don't remember what his motion
I think
was.
he asked,
Have
I think he
the
asked the attorney.
Oh, to have
He
the
would
attorney
make
do
a
it?
motion.
Okay. Yeah, I'll second that.
Okay,
Wait,
Motion.
Whoa.
motion is to, I have the attorney review the bylaws and rules of conduct by January 15th.
Sorry.
Second.
Procedurally, that wasn't the motion I was talking about.
Yeah,
I thought he had proposed a motion to set the public hearing.
he did. That was his motion.
Yeah.
Early, very early on,
Yeah.
and there was no support yet.
So I just want to make sure that either that motion has died or the motion's been rescinded.
I think there's no support, so.
I like this motion over here.
What do you want to do? You want to rescind it? Do you,
Go for it.
okay.
Okay,
Wait a minute, do we need to rule on his motion for the lawyer because that one was first?
Half a motion. Your motion was to
The
set
lawyer
a
can't
public
make a
hearing
motion.
for,
That's what I wanted to do. but
Or-
there's no support, so we rescind it, so go ahead.
but you didn't define for when?
I didn't get to that part.
Okay.
Do we need to rule on his motion with the lawyer having the documents done by the 15th before we rule on this one?
He didn't make that motion.
Okay,
There's another motion pending.
Okay.
But you didn't have a chance to add a date,
I
Timmy.
did not.
So
I just don't want to drag this thing out to May or June or July.
I agree.
I think he already has bylaws all pre-printed with one of his other 100 clients that we can review. Plus, we've worked on them for months. They're all in place. All we have to do is tweak them. I don't think we need more than 2 weeks to bring our bylaws into an area that we can be happy with, knowing that we can amend them. So with that in place,
so shoot for January 15th.
January 15th, we should set a public hearing.
Not on the 15th, but shoot for the 15th to then set a hearing.
Correct. That's how we're just set it for the 15th. And what days are our meeting in January?
I was confused by that. So are we setting?
We're all confused about that
A
because
motion to consider setting a hearing.
the chair said we weren't having a meeting then, so.
We're having a meeting January 15th.
Let's do that.
And
Yeah, you probably can't set the public hearing for the 15th because you won't have time to publish the notice between now and the 1st.
All right.
Following.
at that meeting, we would consider when we would have the public hearing.
just do it now. Pick February then. why are we, just set the date now?
Like there was plenty of time to get it done.
That's-
15.
Timmy, will you do March 4th?
Why not? Let's kick it out to March 4th.
It's part of the motion.
That's part of the motion.
Okay,
I'm gonna be devil's advocate. I'm trying to be peacemaker.
What's
with the
March?
preview. As I now understand it, we can have the public hearing. There's nothing that says we have to recommend it up. So what if we get back, like he said, he thinks he's gonna have 2 weeks. We get back on January 15th. We have a great meeting. You give us a stellar document. We're ready to go. And now we have to twiddle our thumbs until March 4th. Let's get the meeting scheduled. And if we don't feel comfortable, sending it up, we don't send it up.
Pick a date then. I don't care.
Honestly, we can
First
respond.
meeting in February.
I was under the impression falsely that if we have the meeting, then we have to send it up. We don't have to.
I don't care.
what's
Pick a date.
meeting in February?
February 5, February 26.
Which one feels good to you, best to you guys?
And I think we now have two motions on the table.
I'll rescind my motion.
I'll resend mine too. Let's start over.
I make a motion that we schedule public hearing on stripping the planning commission portion of chapter 23 out of the zoning ordinance for February 5th.
Support.
All in favor, say aye.
I,
Aye. Any opposed? None noted. Passes 7-0.
Can I make a comment, Mr. Chairman?
We have a meeting February 26th and March 4th. Or to interrupt.
maybe, I don't know. I haven't
One
seen the
week
planning.
after?
I haven't seen the meeting
Okay.
schedule yet, so.
Member Reese?
I was gonna say the best way to get consensus on the planning commission.
February
is for everybody to die.
Or argue about insignificant things.
Okay, now I want to go back to the motion you made earlier, to have the attorney put together the documents necessary, the bylaws and the code of
That
conduct.
wasn't a motion. He just has 100 clients that already have bylaws and he could share a couple of those with us for review.
Okay,
So that we can actually put bylaws together, not counting the ones that we've already spent months and months on.
Yeah, why would we do that?
Together, come up with the best solution.
That's just gonna create more stir. We're gonna have more things. Let's send him what we have and have him filter that to the best
Whatever you want.
practices.
You guys are the planning commission. You need to come up with your own bylaws.
You're the planning commission too.
well,
Don't,
fine.
don't hide.
I'm just saying, it's like pushing a rope over here.
in any case, you see no problem, Mike, to get the stuff to Madison to distribute to us?
Yeah, I don't need a motion. I know what to do.
Okay, thank you.
Great.
That makes life a lot easier.
Moving right
All
along.
right. Any other discussion on this?
I hope not.
Okay, thanks so much, Mike.
You're
Thank you.
welcome.
Wow, okay.
Sorry.
Now, for the.
Before we move on, actually, one other discussion. So Timmy, are you good? January 15th was the earliest we could do it, but he said we couldn't do it. So this is the earliest we could possibly do it.
That's fine.
Yep.
We just
January
need to do it.
15th.
Yep, no, I get that. And I want to be sensitive. You want to do it quickly. We're doing it the first date we possibly can.
So we meet January 15th, next meeting. Okay, Article 9, Farmland Preservation Subcommittee update. I'm going to ask that the chair of our subcommittee, Member Reese, give us an update.
All right, thank you. I will try to keep this brief. So all of you received today, I believe it was today, some information, a write-up about what we're working on in the committee. I'm not going to regurgitate that all to you. There was also some tables that were included. And then later I sent an email that said to ignore the tables because there were some things that we needed to edit. And so I wanted to elaborate on that a little bit, just real quick, that the tables show a little bit of what we're focusing on as far as what uses and special rights would be allowed in our two predominantly agricultural zoning districts. ARC, which stands for Agricultural Rural Conservation, and FP, which stands for Farmland Preservation. And we continue to, in the committee, tweak those uses. We're trying to highlight uses that we feel promote what we want to see in those areas. For instance, farm stands, wedding venues and farms, things of that nature, community gardening, those types of things are becoming more popular. And there's some gray areas in our ordinance as far as what allows for those and regarding those uses. So that table was kind of a working document that we're working on. We're going to polish that up soon. It'll come back to you in a little bit without a few of the errors that are on it. Okay. And then with respect to the write-up, we basically are working on some goals here. The first goal, and I'm not going to reread all this because you guys can read it at your leisure. But working on, that's what I just talked about, the uses by right and the special uses. The second goal that that we're focused on is what's referred to as TDR, which is a transfer of development rights. And we want to see more emphasis on that. And I know that currently we have 0 farmers enrolled in any preservation program. The county does a lot of this work, and there's nothing going on with that. Trustee Nordhook has really helped us, and he went to the township board and has managed to get them to seek $100,000 in funds that could be used to incentivize farmers to take advantage, or anybody really, to take advantage of preservation of land in the township. And so that's a huge start to jumpstart us. But what we really lack right now is the language in the zoning ordinance to put this all together. And so that's what we're working on as one of the goals. And then the third thing is we're trying to take that program that, again, I'm skipping over my notes here because of the lateness of the hour, but we're trying to take a program that's currently in place in Grattan Township, where they, if a developer comes in and he wants to take a 100-acre farm and put in 50 houses, okay, he's got to take a portion of land somewhere in the township, not necessarily in that 100-acre parcel, but somewhere else in the township, and it ties together with that PUD. So if, I'll give you an example, if a guy wants to build 100 houses over here on 48th Street, okay, on a piece of land, maybe he can fully build that piece of land on 48th Street right over here. But on Buttrick or Snow, he's got to preserve a large amount of acreage. Maybe it's equal to, maybe it's 50% of it, that's a moving target, but it can be non-contingent. So, and still be part of the PUD. So both those parcels, even though they're miles apart, can be part of that same PUD, and they're tied together in perpetuity. So we're working on that. And then the third aspect of this is to build on what Grattan Township is doing and is the most successful of doing in Kent County so far. They've preserved more land with this method than anybody in Kent County, and take it a little bit further and build on something that I think started kind of with your discussion, Alan, is that we talked a bit about height bonuses and things and density bonuses, and roll this into being applicable in more of a commercial or type area, or an area we want higher density residential. And so maybe if you want that third story on your building, then that third story is going to cost you 50 acres of farmland over here. I'm just hypothetically throwing out numbers here. Okay. And so there's some tie in there. And so what the committee really needs to know, in giving you this updated things that we've been talking about, is specifically, does the PC want us to work directly with McKenna to make those bonuses and goals a reality? Or does the PC want the subcommittee to engage with legal counsel to draft up ordinance that does these things? I think that's kind of where the subcommittee is at. It's come up with a lot of good recommendations, but they're kind of loose ends because we don't have we've got ordinance from Grattan Township, we got an ordinance from Lancaster, Pennsylvania that we've looked at, spent a lot of time on. These are big, thick manuals, but we really feel that before we take it to the next level, we probably should engage some more people and not have us draft it, but have them kind of put together something that would be better to present to you. And I think that McKenna has asked to meet with us so that what they're working on with the master plan kind of coincides with what we're doing, so that we don't get, I hate to use the analogy twice, but the cart out of the horse. Ryan, I think you can build on this a little bit.
Well, maybe an easier way to picture it, as I understand it, and I'm not an expert at it. you can't just say, hey, you know, you want to build a single family home. In order to build a single family home, you gotta, you know, allocate a farmland. It doesn't make sense. So Grattan figured out a way to do that. Within a PUD, within a PUD, you can have this tit for tat type of relationship. So in Grattan, it's only within a PUD.
Right.
That's what we were originally looking at until McKenna came to us and started talking about these bonuses. McKenna was also saying we need to do less PUDs. We need to have our zoning better, so we're not doing as many PUDs. So our thought was like, well, can we tie the bonuses to the same type of thing? So we're looking at having two different hooks within the ordinances. We can try to get more open space through PUD development. We can get more open space through bonus development. And what we thought was novel about the bonus development was it kind of makes more sense, right? You're going to add density here. You want a third story, fourth story. Well, the more density you had here, then you have to add some open space here. So we're always at neutrally buoyant.
Get my fire truck.
That
So, well said. So I think what the subcommittee would like is for the planning commission to give the nod that we keep moving forward and that we work with McKenna on the next phase of this so that we can quickly come back to you guys with something where we've connected more of these dots and it's not a lot of ideas and goals floating around. We want to narrow it down a little bit more. I don't know. So it's a little bit more shovel ready, so to speak.
Yeah, I agree with, I'm good with McKenna. I'd rather you do that route than the lawyer route.
why?
Well, I think McKenna's gonna be cheaper, first of all. And secondly, I think McKenna is already working with us on the bonus structure for the, you know, the heights. And so I think they'll probably have a better opportunity to reach out to other people at Grattan and, hey, how are you guys doing this? How you doing that? I don't know. I'd rather go McKenna than going to lawyers and having an ordinance.
I agree, and they're already working on the master plan. And we're just trying to catch up to the master plan. And I think if we work together, we can coordinate that.
Can I throw out one more quick thing? There's another way to get this done and potentially have it be paid for as well by another entity through Kent County, I believe. And, excuse me?
Next up, housing next.
Housing Next, I think is the name of it. And so there was some talk in the subcommittee about potentially asking Housing Next to talk with the planning commission to see if there was interest in maybe aligning ourselves with them. And then as if you adopt their goals, I think, then they'll offer you $50,000 to write the ordinance. But I don't know if their goals align with our goals. That would be the thing that we would be finding out by having them come in and talk to us.
I would add something between the two of you. So you said you'd rather work with McKenna as opposed to a lawyer. It's not an or proposition. We can come back and ask again to work with lawyers. We're gonna have to work with McKenna, and then eventually it's gonna have to go before lawyers. Somebody's have to draft
The
it.
lawyers got it.
So eventually it will go to the lawyers. And what Scott's saying is we can try to offset some of that cost you're worried about.
Yeah.
We can do McKenna, then lawyers, or we can do just lawyers, we can do none of the above. But we can do McKenna, come back and give you an update, and then you can authorize the lawyers. But at some point, the lawyers are gonna have to get involved.
Why don't we do
I
McKenna
think
first?
Timmy had.
Yeah, I understand there's always a hook when somebody's giving you money.
Yeah.
And that
That's-
hook,
You know what's worth a listen though?
that hook's usually not pleasant.
Do you think it would be at least worth the listen?
I really don't think so. I've listened to several of these programs offered by the city of Grand Rapids, Get the Lead Out, and there's a huge hook on that one. And, getting windows put in, there's a huge hook on that one. So there's a lot of these programs, you're paying for them, so
One way or another.
you got that right.
Well, that's the update. It sounds like nobody here is opposed to us working with McKenna, so trying to streamline this. So I think that's the direction we're gonna move. And you guys are always welcome to come to our meetings too, you know, they are open to the public, so anybody can come in
Can
sit
I
in.
go a step further in the ask?
Yeah.
So we'll work with McKenna, and that's gonna be a different section of the ordinance. Can we get legal fired up on doing the PUD side? We have the template from Grattan. I don't think we're gonna really change that much. We might change like the ratio of preservation to development. But can we have them start looking at?
I was a little confused because you said that, maybe it was, I thought you said the lawyers said, get away from, you were doing too much PUD, get away from the PUD. Or was it McKenna that said that?
McKenna said that, but I don't think we're still gonna have a PUD section of the ordinance. They want us to use it.
But I think they have some experience in that area there. You might want to, before we jump to the writing the check for the lawyers, which I always am in favor of course. I think that we ought to talk to McKenna and see what they can offer there,
Okay, that's fair.
just
That's
as a
That's a
threshold.
good point. So I like it.
Yeah, I would say to Joe's point, this isn't like we've already, or committees discussed with McKenna, them already agreed to do the work. I think this was intended for us to.
Reach out to them.
get permission
And get your blessings.
to do work.
Right.
Not saying
Yeah.
it's written out and you just need to agree.
Right.
And I need to coordinate with Madison a good time and date to have them come in to talk to us at the Farmland Preservation Subcommittee.
I think they're intrigued by the extent to which we're trying to take Grattan and expand it. I think McKenna is, so
Yes,
that works. in our
that
favor.
seemed to be,
What are your thoughts about having maybe a representative from Grattan coming and talking to us?
We've already.
we've already done that, yeah.
But we may ask him again. Dennis Heffron.
Okay.
Heffron Farms.
Yeah.
He was great.
It was.
And he talked to us for like 2 hours,
Yep.
real casual, real easy going about it.
Okay.
And a lot of good thoughts. I mean, they've really gone through this program. And, you know, I think boiled it down to something they're very happy with. And I think it's just a matter of kind of tweaking it.
And we've met with people from King County a couple times too on the farmland preservation.
The subcommittee that was gonna meet 4 times and be done has met how many times?
That's the way they.
I meant to count it and I didn't, but we've
Well,
met at least a dozen, yes.
I think we spent
Almost weekly.
4 or 6 meetings just on uses.
Yeah, I mean, we've been meeting a lot, which is why when we have these discussions instantly about potentially going from 9 to 7 came up in discussion. That's my biggest hesitance is that there's so much we're doing and I feel like we're behind the ball. We could have another, and I know Manager Smith wouldn't want to hear this, but we could have another subcommittee working on correcting something else. And maybe that, you know, maybe that would help to get some of these things fixed that we're trying to work on. You know, we have that list of, and that's part of the problem is I don't know where that draft list is, but I know the previous planning director, Brian, was working on a big list of things that we were going to correct in the ordinance. I know Madison has a list in her mind of some of those things, but
She's adding to the list. finally.
I see it right now. She's writing stuff down right now. And the problem is that nobody's really monitoring that. And so it just kind of bounces around, but we never take it up and correct it. But we should be setting public hearings to fix the commercial composting issue. The name commercial wasn't intended to be there. It should have just been composting. It's real simple.
We need
Set the
more
hearing and
people.
take the word out.
I think Member Rollins trying to raise that crippled hand. He wants to chair a subcommittee on zoning ordinance. No, I saw those fingers moving. No, how come I help you raise it?
I just would like to see us do more and I feel like with more people up here, that enables us to be able to do that. So that's my only plea in that.
And I'd just like to say on the meeting minutes and the meetings themselves, we started out at 1 hour. Now we're up to almost 2 hours for the subcommittee meetings. And the minutes started out like 2 pages. Now we're up to about 5 pages. I mean, trying to document all the stuff, and that's not including all the side
Tables
discussions.
and other things, yeah.
we have going on. But I think we're accomplishing a lot. I think we're making some good headway on this thing.
I went up to 2 hours on a very simple agenda.
I'm trying to make this brief, Timmy. I really am.
Any other
Are you guys
questions?
planning on wrapping up your farmland, your committee? Or-
We'd like to wrap it up. I would have hoped that we would have been done by the end of the year, but I think that realistically, it's probably going to take us another month and a half to get something a little bit more tangible that's ready to come to you.
I think we need to set a deadline when you're done and get that out. 'Cause like I said, you're already twice what you thought you were gonna be.
Yeah.
Another month and a half.
Well, and I think part of the problem there is that we've in all of our education here of meeting with people, we found that there's so much more to this. You know, initially, when I asked that we take up farmland, which was at the end of my tenure as chair, and I was told that, well, we got to deal with the wormies thing first, and then you can deal with the farmland. At that time, it was more or less just looking at the uses that are allowed and how big of splits were allowed out in that farmland area of the township. But now we've gone in a whole new realm of transfer development rights, and it's not just about uses and parcel size, and we're talking about, you know, all sorts of things. So bonuses,
Scope creep.
scope creep, yes.
Plus you gotta stick in the mud, that's where your scope stops.
But I think we're gonna get a much better product out of this for the township than we would if we had just said, well, instead of a 4-acre split, you can only have 10. I think this is, in the end, where we want to be. I think Grattan is leading this, and I think what we're talking about would be transformational, and other communities, I think, would be taking a very close look at it.
I don't know if it's scope creep. I think the tasking was exactly what you said, and to figure out a way to actually, we have a farmland preservation zone and we have 0 farmland preserved.
Right, exactly.
So half of the task was figure out a way to actually make it happen. And we've learned 2 really valuable tools. We could have turned a blind eye to them and said, no, we have to be done, but.
And I think we need to do a better job of marketing the farmland preservation issue, because we went to that meeting and there were like no farmers showing up. I
Yeah,
mean,
the county's not doing a good job on their end,
No.
but we don't need to hash out these details here. This is things that
We're
we're working.
working on getting the word out. We're gonna.
Yeah.
That $100,000, we're asking for more contributions from our residents. And that's not only for just transfer rights, it's for the actual purchase of land as well. So we've got to have some details in writing.
What is
The
interesting,
committee did come up with one thing that I think is very interesting that you should all consider. At a time when the supervisor has to make another appointment to this panel, technically we do have a vacancy right now, but we think that a farmer's wife would be a great addition to the planning commission to have that perspective, because we lack a female perspective and we lack a farmer. So that fills both of those spots. It's just, and Grattan Township got there because they had a farmer on the planning commission. Dennis. And so it seems like that would be a great fit to give us some different perspective, but yeah, go ahead.
one interesting thing for those at the meeting or not at the, so at the Kent County, we had mentioned that there's a proposed budget line for $100,000 for farmland preservation.
And accusations.
Okay.
Sure.
Sure. He had mentioned, I'd asked, will that help? Can you count that in your matrix? So we're more likely to get Kent County to match. He said, absolutely, but I'll have to on a yearly basis revisit that because you might not allocate funds every year. I have since clarified with the township supervisor and I believe the township manager that $100,000 is not a use or lose it. It is going to be paid into a foundation where that 100,000 will be there after this calendar year. Is that correct?
I don't know about the word foundation.
Okay, what is
It's
it?
a fund.
It's in a fund that does not expire at the end of the calendar year.
There's a big difference between a foundation and a fund.
Okay,
too.
so
it's
But it's preserved. It's not a use it or lose it. So we should circle back with Kent County and let them know that going forward, they can monitor it as the fund depletes, but it will not expire.
And I really appreciate the township board taking action on this, and I said so to
But
them.
you have to watch and make sure that it continues, because down the road, different people will sit here, different people will sit at township board. And at some point, a board may decide to not put the money in that fund anymore. The township has a tendency to do that
Right.
on a lot of funds. And then it becomes, I don't want to say obsolete after a while, but it becomes a little weak.
But there's a difference there. That would be adding more funds. The 100,000 is earmarked.
It's a huge jumpstart, and that's great.
Any further comments about the update?
No, good job.
Thank you.
Okay, I'd like to move on. Article 10, acknowledge visitors and those wishing to speak. We got anybody online? Nobody in the audience, nobody online? Okay, moving on. Any other business? None noted.
Oh, can I make one quick comment?
Sure.
Because if I don't, I'll forget it for next time. I've been thinking a lot, especially when I read through the minutes. And in both cases at the last meeting, we tabled both cases. And in thinking about that, I think, or I shouldn't say both cases, there were two cases in the last meeting that we tabled. One was related to a cemetery, and one was related to an accessory building. And I think we probably could have been more efficient if we had, somebody's saying there were three cases.
Well, we voted against the third one. We voted that one down.
Okay, I was gonna say, with an accessory building that came by, rather than table, we probably could have just said, we'll approve you up to so many feet and let them hash out the details of how they got there with staff and not had to have them come back in tonight. And with the case of the cemetery, I think we probably could have done a similar thing and said, well, we'll approve it, but rather than ask them to redesign it with setbacks and rules that were similar to our rules, we could have approved it with rules that mimicked our rules and subject to the setbacks. And the only reason I'm bringing this up is I don't want the planning commission to become big on tabling things that it doesn't necessarily need to table. And so that was the only comment I wanted to make. I just wanted to make sure that at the end of the day, want to be as efficient as we can for the people of the township. And if we can find a way to be efficient and not make them have to wait 2 weeks for us to have another meeting and come back in to rubber stamp something, we should certainly give them that respect.
Agreed.
Thank you, Sid.
Thank you. I'd like to make two other comments. First of all, I want to thank Madison for working her tail off to help us. Without a, community planner, she's really carrying a handful here, and I appreciate all she's doing for us. Thank you so much. The other thing I wanted to mention, just kind of on a personal note, is many of you came to my Model Railroad open house, and I hope you enjoyed it. I appreciate you folks coming. Some of the board members also attended. Many of you brought your kids or your grandkids, and that was fun to see. And I am open to anybody that wants to have a private tour. Just give me a call or drop me an email. And you're welcome to come on over, and I'll even let your kids run the trains if they want. So thank you all for coming. Yeah.
Can I throw one more thing? If anybody wants to see a list in a little easier format of the uses that were in the table that we said had some errors, Ralph has some copies of that. If you'd like a copy to review, it's available if you want to take going home.
Okay.
With that, I make a motion to adjourn.
I was gonna say, I can send out the meeting calendar.
Just send it out. Yeah. So I can start marking those on my calendar.
So are we only meeting once in January? So I know it's,
The 15th of January is our meeting date, Martin Luther King Day.
and that's the only meeting.
That is the only meeting in January.
Yep. Okay, we've got a motion to adjourn from
From me,
Reese.
he's supported.
It's been supported. All in favor, say aye. Aye. Any opposed? It passes. Or adjourn.
See you next year.